in the neighborhood, the Girl Scouts will be at our museum on 595 Long Pond Road, 1:30 to 4 on Sunday, selling their cookies. So you can, we try to support other organizations in town. We do have our museum is generally open on Sunday afternoons, so you're always welcome to stop by. Tonight is James Valenti. He was born here in Rochester and has lived in the town of Greece for 22 years. He has been an attorney for nearly 34 years. He holds a BA from St. John Fisher College, Juris Doctorate degree from Akron Law School, and an LLM law degree from Buffalo Law School. He is currently an associate professor of criminal justice at SUNY Finger Lakes Community College. So please welcome Jim Valenti, professor. And there he is.
Well,
Professor
thank
V.
you.
And
Thank you. And thanks everyone for coming out.
You can put the speaker view.
Can you
Oops.
Can you hear me okay there?
Yep.
We good on that?
We're good.
All right. Let me start out by talking about where I'm going to go with this. And I know there's going to be a Q&A later. We may or may not get to some PowerPoint here, but I'm going to be talking tonight about a famous case from Rochester, New York. I will just tangentially at the end mention a couple of other cases, but you know, Rochester's had some cases that have gone to the Supreme Court of the United States, and I'll start out with the main event. And before I do the main event of Nebbia versus New York, I'll set the stage a little bit. So this is going to be a little bit of macro and a little bit of micro, some history, some law. Okay, and we'll do that as a potpourri here. Okay. Now, one of the things that you have to think about is the court over the years has dealt with, when I say the court, I mean Supreme Court of the United States, SCOTUS, okay, as opposed to New York State Supreme Court or anything else like that. But SCOTUS has dealt with, even from back to the late 1800s to especially 1905 and 1930s, with this issue of how do you deal with, how will courts deal with a state or federal government, quote, tinkering with or creating laws that affect business, private business. And I have to tell you that there is historically a mixed bag, so to speak. Let's go back to 1905 real quickly here, just to set the stage and the context. And that is, it's another New York case. A lot of famous cases come from New York that make it to the Supreme Court of the United States. New York State passes a law that says that bakers cannot employ employees in the bakery business to work more than 60 hours in a week or 10 hours in one day. Otherwise, they will be fined or, convicted. That's the famous, although infamous, becomes infamous, Lochner versus New York. And the reason I start with that case is that every law student in America studies it. It's an issue that's been around in various sorts over the years, and various parties throughout history have accused the other side of, quote, Lochnerizing. And I'm going to explain real quickly what that means. The Supreme Court had to grapple with whether the state of New York, under what they call, under what is called in constitutional law, police powers, had the authority to make that law with regard to employer-employee maximum hours worked. And the question is, did that violate something in the US Constitution? Well, what are police powers? police powers have nothing to do with police. They have to do with a state's right to make laws, a state's right to make laws for the health, welfare, and safety, and sometimes morals of its constituents. We see those laws all around, infant car seats, etc. You can see a lot of different laws for health, safety, morals, etc. So going back to 1905, Lochner is convicted. His case goes to the state courts, and he argues in the Supreme Court through his lawyers that this violates what is known as the Due Process Clause of the 14th Amendment. There's a due process clause in both the Fifth and the 14th Amendment, but the court makes this they find a right in the Constitution that is, quote, not there. And it is what we call an unenumerated power. And they find a liberty of contract in the 14th Amendment due process clause. I don't want to get too heavy or too out in the weeds here. Okay. A majority of the court strikes down this law using the due process clause. They say it violates the liberty of contract in the 14th Amendment. Well, needless to say, Oliver Wendell Holmes writes a very strong dissent, and he argues that it's not up to the court to decide whether this is a wise law or not. It's only up to the court to decide whether it violates the Constitution. Engage in judicial restraint, common theme, Oliver Wendell Holmes, Antonin Scalia, don't, in effect, act as a super legislature. It's not your job. It's only the job of the court to determine whether this violates federal law. And of course, the federal law here is the Constitution. Well, I'm going to fast forward to 1934 and slightly before that, because remember, it takes a while. If a decision comes out, it takes a while, usually a few years, to go through the state courts. But we're going to deal with another New York law, and I'll try not to, again, get out into the weeds too much here, okay? But it's a depression. Many people don't have proper food, clothing, etc. We all know what was going on at that time. And of course, my late parents were the Depression era. And of course, I had grown up with, these stories, as many of us have. So there's established by New York State a milk board. The New York State legislature establishes a milk board. And I'm going to try to share my screen here. Can everyone see that? Can you see this share or no?
No.
I may have to go back in and just adjust here on my bottom here. Sorry about that. You know what? I'll come back to that. I apologize. I'll come back to a couple of these slides. So the milk board is established by the legislature, in effect, to help out the large producers of milk. If you produce milk and you're a large producer of milk, you've got some troubles. You don't know what the supply and demand will be, and milk is perishable. So many of the large producers of milk would have to flush milk that went bad, because some weeks the supply would be too high, or the demand low and vice versa. So in order to protect the large producers of milk, the milk board sets a minimum price for milk at 9 cents a quart. And in effect, you could be fined. They have really either a criminal penalty, like a $5 fine at the time, or they could proceed civilly. If you are a grocery store or retailer and you undersell milk. So what's the law involved and what's going on here? Well, it's whether the state of New York, through its milk board, has the right under its police power to tell a retail store that they can't sell milk for less than 9 cents a quart. Of course, as I like to tell my students when I teach this, excuse me, from Nebia's point of view, it's none of your business what my business is. If I want to undersell it, it's my milk. And that the state has no interest, the government has no interest in regulating it. Well, what happened? Well, Nebia, who I'll talk just a few minutes here about Nebia. Nebia he was born in Italy. He came here at about late 1800s. He came here at age 15. And he has a grocery store on J Street. Many of you know J Street. Actually, it was 348 J Street, okay, right here on the west side. And for those of you who don't know, off Lake Avenue, etc. And he had a store, a mom and pop store, and he undersold milk the following way. You could buy for 18 cents, and of course, 18 cents at that time, many people didn't have anyhow. And but 18 cents, you could buy 2 quarts of milk. But what he did was he threw in a 5-cent loaf of bread. And when he did that, he was charged, fined, convicted in city court over that. And you know what his argument's going to be? Who's the state? What police power do they have to make this law and fine me for underselling milk? Okay. So he goes to city court and he is convicted, fined. And at that time, and even today, oddly enough, appeals from the criminal parts of county court and city court, justice court and city court, those appeals go to Monroe County Court. And I always preface my talks by saying that none of this is legal advice, by the way. But his conviction is affirmed by county court. And just like today, our high court in the state of New York, just like it is today, is not called New York State Supreme Court. It's called the New York Court of Appeals. In New York State, the high court of the state of New York is the New York Court of Appeals. It is what is known as our court of last resort. And the Court of Appeals sides with the state of New York as well. So far, he's 0 for 3, Nebia. They are all confirming his conviction, quote, conviction. They had, as I said, they had the right to actually, the state could have actually proceeded civilly over this, but they did proceed criminally, and he paid, a fine. But the case goes, he appeals to the Supreme Court of the United States. And none of the members of the Supreme Court of the United States are the same members as before in 1905. But if you knew something about Lochner, you would think that you would think that he would win, that Nebia would win. And he doesn't. He loses in a 5-4 decision. And at that time, the swing vote one of the swing votes was Justice Roberts. Of course, we have Chief Justice Roberts today, but they had a Justice Roberts then, and Owen Roberts. And he's going to be a justice that's gone. We're not going to talk about this, but he's going to go back and forth on some of these liberty, Lochner, regulation, substantive due process issues. But he sides with the quote liberal members of the court, and I always use that liberal conservative in these areas. When it comes to the court, it oftentimes has different meanings. Judicial conservative, or fiscal conservative, or when people would say use different labels. In this type of an area, you have to sort of keep in mind what we're talking about, judicial interpretation. But the court goes the other way. They don't actually say Lochner's no good. Lochner was, the Lochner decision was wrong because the court was acting as a legislature and not a court and just interpreting the law. But they do go against the Lochner reasoning. And the majority is really picking up on the Oliver Wendell Holmes dissent. So they uphold the state of New York's fine against Nebbia. Nebbia later, he said, I abide by the law. And of course, he had gotten quite a bit of a publicity over it. And he actually, I think put a sign in his window, store window, that said, yes, we comply with the law. And then he did not undersell milk. From his point of view was that that it was a depression and that women used milk as formula, and that, he was just in effect not charging a lot for it. So there's another case, and I'm going to lead into something that, and I always tell my students that when I teach Supreme Court history, and I haven't taught that in a couple of years. I've actually taught it at Brockport before, and I've taught it at the school that I'm at. I like to say that history repeats itself. Constitutional history repeats itself. But we're going to see how that happens in just a couple of minutes. Earlier in that same year, the court was confronted in a very famous case. And I have to tell you, every law student in America studies Nebbia, Lochner, which is an even bigger case, much bigger, and the following case that came out a few months before Lochner, and that is the Minnesota mortgage moratorium. It's the Blaisdell case. And make a short story long, as is my specialty, it's going to be another law, that the Depression era law. It's really this, as well as the Milk Control Act, is really New Deal legislation at the state level, as opposed to the FDR federal level New Deal legislation. But the state of Minnesota, because many farmers were losing their property, there was a law that said, passed by the legislature in Minnesota, that said that judges could use their discretion to, in effect, loosen some of the rules and help out debtors in the time that they have to redeem property. Okay, in other words, what they would be doing was they wouldn't be allowed to forgive the debt owed to the lender or bank, and but they would be allowed to give the debtor a little more time. And this did violate the contract And there is, by the way, a separate part of the Constitution called the contract clause, that says that no state shall interfere with a contract, make a law that interferes with a contract. And clearly, Minnesota passed a law that interfered with the contract between the lender and the debtor. Yet the Supreme Court upheld that law. They ruled in favor of the debtors, ruled in favor of the law, allowing the contract, in effect, to be, how could I say, they could loosen the rules a little bit without forgiving the debt to help out the debtors during the Depression, so the farmers wouldn't lose the debtors wouldn't lose their property. Okay, mortgagors, they would say, wouldn't lose their property. And 4 justices known as the Four Horsemen, they objected to this. They were, if I can remember, the Four Horsemen, by the way, was is a reference to the New Testament book of Revelation during the apocalypse. And the Four Horsemen were McReynolds, Butler, Sutherland, and the other one escapes me. And I'll probably think of it in a few minutes here. Or on the way out, there's an old saying, the best questions lawyers think to ask are the ones that are going to hit them on the way out of the courthouse. And I'm purposely not looking at a note. And because to be honest with you, I like to just do it this way. And I've been doing that more. So I'll try to think of the other one, all right, so that I don't get distracted. But anyhow, the Four Horsemen were fiscal conservatives, and they believed that the court shouldn't do this. Now, I'm going to tell you right now, the court will go the other way later and very soon, and something that is probably is an issue today and was an issue then. And that is that very soon after this, that there will be federal legislation passed. Well, there will be, FDR will put forth his New Deal. And as part of the New Deal and part of the legislative acts in the New Deal, the president, FDR, will be given what the courts will find to be too much authority in effect, making regulations. And the court will now start going the other way. And the court will now start striking down New Deal legislation, of course, federal legislation, right? Protectionist legislation. What is really New Deal legislation? Government legislation at the federal level that is protectionist legislation meant to deal with economic decisions or economic emergencies. That's really the same thing that you have going on in the Minnesota case, and the same thing that you have going on in the in Nevia. Okay. Now, what you have to realize is the court will now. Van Devanter is the other one. Thank you. Van Devanter. No, well, see, I told you, I always tell my students, if I'm not going to look down and look at anything, and I'm just going to do this like this, it's a live show and anything can happen. So, well, anyhow, what's going to happen after this historically? We're going to start in 1935. 1936 era. What's going to happen? The court is going to strike down New Deal legislation. As a matter of fact, in one day, you know that in 1929, when the stock market crashed, right? Didn't they call that Black Tuesday? Wasn't that, well, there's a Black Monday in Supreme Court history, and that is on a Monday when the Supreme Court of the United States struck down, what was it, 3 New Deal programs, one of them being the sick chicken case, the Schenkter case. And this is when FDR will, in effect, go to war with the Supreme Court, those 9 old men, and he would then usher in his court packing plan. A plan that's been thought of today, a plan that I don't want to go into the politics of today of that being brought up, sort of beyond the scope of this, but very interesting that the court packing plan, Roosevelt says that that the members of the court who are 70 years of age or older are having trouble keeping up with their workload. So for each one who's 70 or more, he should be able to appoint a justice, which would of course give him 6. And well, it would give him, it would certainly allow him to expand the court to 15. And I have to tell you about the court packing. Justices on the court were not happy with it. There was even testimony before Congress. His lead man in the Senate was Joe Robinson, a Democrat, who was trying to help lead the push for the court packing plan. And Joe Robinson actually has a heart attack on the floor of the Senate. And to make a long story short, even many in Roosevelt's party didn't want any of it. And of course, Republicans didn't want any of it, or at least not that many that I have no idea what the count was, but it was unpopular in both parties. So a little while later in 1937, there's this case called the West Coast Hotel, a parish hotel, and it is West Coast versus a parish, is it? And the parish case, as I call it, and I'm not going to brief it. Basically, you'll see that in 1937, the court starts to go the other way and starts to uphold New Deal legislation. And I won't go into all the judicial interpretations and theories about this, but the court has traditionally since then been very given much deference to many legislative acts along those lines after that, for a long time after that. So even though Roosevelt doesn't get the court packing, by the way, he will get so many appointments because he was elected 4 times, that his appointments on the court will end up being really about 8 of the 9 over a certain period of time. And they will be favorable and will not be striking down, will not be striking down what would have been struck down in other types of legislation. So let me try to add a little bit to this. Let me just tell you that if you go back to John Marshall, all the way back to McCulloch versus Maryland, and I always like to say our founders in our early court, they had imperfections, they had things that we had to fix, problems societally, etc., that we had to fix by amendment, etc. They weren't perfect. We know that there were certain issues such as slavery that had to be dealt with, but they were extraordinarily insightful and brilliant, insightful. I mean, think about it, checks and balances. The people elect a president who then nominates federal judges, but they can only serve if the Senate confirms them, But if they serve, then if they do confirm them, they have independence by getting life appointment. By the way, if you want to limit the term of justice, any federal judge, you have to amend the Constitution because Article 3 says they serve for good behavior. That means life, unless they are impeached and removed, unless they die in office, unless they resign, or unless they retire. So bringing you back to this part here, okay, John Marshall said, Chief Justice from 1801 to 1835, and I'll talk just a little bit about that, just give you a little bit of, did you ever see the Liberty Bell? You know, I like to write poetry about law and history. And did you ever see that crack in the Liberty Bell? He's got a couple of them. You know how that came about? Well, when John Marshall died in 1835 in office, the whole country was in mourning, and so many of the bells, church bells and other bells were ringing. They told so long, and the one in Philadelphia told so long that it cracked the Liberty Bell. And now you know how the Liberty Bell was cracked. But John Marshall said in a case called McCulloch versus Maryland, he said, you know, this state versus federal power thing, which is a little different about what we're talking about here, a little different, but he says, you know what, that's been around since our founding, since the drawing of the Constitution. And he said, I bet it's going to be around as long as our republic is around. McCulloch versus Maryland is 1819. Think about it. We still argue about that today. We still argue about state and federal powers, and we also argue about legislation and if it's gone too far or not, and about whether courts have gone too far, whether they're engaging in what we call judicial activism or not. And sometimes different justices and people accuse the other one of Lochnerizing. And by the way, if you're having a constitutional talk with someone, and you probably could gather by now that if you are, and you accuse the other one of Lochnerizing, that's a diss. It's not a nice thing. Okay, so let's put it in perspective. We have these cases that go from right here in our own backyard all the way up to the Supreme Court of the United States. Because I want to have a question and answer period, I will mention that if people are interested, there are some other cases from Rochester that have gone all the way up. One of them was Valenti versus Rockefeller. And that case dealt with the governor's ability to fill the seat of upon the death or the vacancy of a Senate seat. And what are the governor's rights? And of course, Rockefeller at the time had filled the seat left by Robert Kennedy in 1968. So there's one there that went all the way to the court. It was a per curiam opinion, so it's very short. Excuse me. However, there's another one, Town of Greece, the prayer case, the Establishment Clause case, and the question of whether prayer before a public meeting called legislative prayer, and the court had grappled with that in a case called in 1983, the Chambers case, whether that law, that practice, or the way that practice was done violated one of the two prongs of the First Amendment's religion clause. And that case, a landmark case, another one here, right from, well, less than, I don't know, maybe a mile and a half from where I am. And so there's that one. There's also another one that's interesting from a criminal law, criminal procedure point of view. I should say constitutional criminal procedure. And that is a case called, oh, I just had a power outage and the power went out in my head. And I'll have to just, I didn't plan to to talk about that case, but it's a case that where the Monroe County DA's office versus the Monroe County Public Defender's Office. And it had to do with detention upon arrest and how long someone can be detained before they're really under arrest, investigatory detention. In that case was a case out of, I believe, the 70s. And why it's escaping me, I don't know. But that one wasn't even one that I was going to put in. But there's another one there that criminal procedure buffs would know about that came right from our county here. Okay, so I'll probably think of that one in a while, but haven't taught that one in many, many years. So the name escapes me. Now I thought what I would do is just leave you with a macro of where we are. No, it's not that. Well, I just saw that. Thank you in the chat. Now I'll think of it in a minute. It's a criminal procedure case that you really wouldn't hear about unless you were in criminal procedure realms there. But Dunaway versus New York. I just got it. Thank you. The power is back on, and there it is. I always tell people, again, it's a live show, and anything can happen. I do this game sometimes with students that sometimes I'll say, I can't memorize the justices, but I'll tell you what, you give me a year and I'll try to name 7 of the 9 justices or all of them. And if I can't, I'll let you go home early. But if I can, you got to stay. So I tell them, I don't plan these in advance. You can pick one. And you know what? Sometimes I can do all 9 and sometimes I can't. But I tell them it's a live show and anything can happen. And that's what makes it fun. So if you've got one, let me know. Yes, about 15 years ago, the Nebbia case was submitted to the city historian for publication. Well, that was yours truly. I could talk with you in the chat about that later. Now, anyone have a question about that? I thought what I'd do is I would just open it up right now to any questions related to any of those, or I don't know, stump the professor with, I don't know, names of the justices and, you know, I don't know, different time. How's that?
Sounds good.
Thank you.
All right. So we do have a comment earlier from Andrea about interesting, especially considering the current debate over various forms of relief and restriction in response to the COVID pandemic.
Yes, you know, this is one where, and I tell people, judicial philosophy. You know, there are different approaches. There are certainly opinions that I like, certainly opinions that I don't care for. Excuse me, that I disagree with, but. As Justice Breyer mentions, he says that, you know, the court is actually unanimous about 40% of the time. That's 9-0. That's actually pretty surprising. It's more of the high profile cases where they differ, but courts have, that's why we have 9 justices have differed over the years many times. And a lot of it comes down to judicial philosophy, interpretation, and every once in a while, you know what they say, politics makes strange bedfellows. Sometimes Supreme Court interpretation makes strange bedfellows, and you usually know how justices will go, but you don't always know how they're going to go down on these things. And sometimes you'll get flips on things that you don't, you know, if you'd like me to talk about those, I can do that. But I like to tell people that I'm generally filled with information that a lot of people don't care about. But I know that you care about a lot of this because you're here. I appreciate that. But yeah, how they're going to interpret this, there's going to be different theories about uh, the approach and how much deference they give the different laws. And I always tell students, you got to have something, if you're a judge or a lawyer, something to hang your hat on, a law or part of the Constitution why you think you win. And I tell people to approach these cases like that. So the answer is that I think that, well, that one's too big. That one's too big to tackle. But I'll maybe I'll take my next question. You're right. You don't. We don't know how they're going to come down on these. I mean, we just had one recently with one of the ones from California on the houses of worship that had come down, and there's an awful lot going on. I have to tell you, COVID has doubled my work as a professor, and it's so hard to keep up with all the cases and all the issues. We'll take our next caller on 1-800-Professor V, as I like to say. Is there another question?
Currently, no. Whoops, here comes one. You can't predict how justices will rule after their appointment to SCOTUS. Didn't Eisenhower regret Chief Earl Warren?
Yes, he did. Very good, Maureen. And I'll tell you a quick story about that. And then I have to tell you, over the throughout the years, I've been blessed to sit under lectures by different justices, meet many justices who've served at different times. I have to tell you, they one time asked Eisenhower what was his biggest mistake as president, and he said, naming that expletive Earl Warren Chief Justice. And then another time someone asked him, of course, when he wasn't president anymore, what was your biggest mistake? And he said, two of them are sitting on the Supreme Court. Of course, he meant Earl Warren. I don't know if anyone knows the other one he meant. It was William Brennan, who will become a leading liberal on the court, who, this leads me as a teachable moment into something I was going to talk about a minute ago. And of all things, the flag burning case, Texas versus Johnson, it will be William Brennan who will write the majority opinion saying that burning a flag is protected speech under the First Amendment. It might surprise you that the leading liberal after him on the court, who was on the court at the same time, but then will take up that mantle, is none other than John Paul Stevens, appointed by Gerald Ford. He will be a leading liberal on the court. John Paul Stevens will actually rule he will be in dissent there and saying that you do not have the right to burn the flag. It is not protected speech. And if anything, you think he would have been a civil libertarian, so to speak, on that. Of course, he was a veteran, I believe. And many of you might not know, but the leading, then later leading, or even at the time, conservative, and I have no problem saying that, in my personal opinion, Antonin Scalia, probably one of the 5 best minds ever to serve on the court, legal minds. Even people that didn't agree with him would talk about his awesome ability. And he actually went with the majority on that. And his reasoning was, you know what? I don't like flag burning, but I'm not the king. And the First Amendment says that people have freedom of speech, and the government shouldn't be in the business. He said this in a speech. He was in England, and he said, I never slept so well as the night I voted with the majority, of course, that was Brennan writing, in Texas versus Johnson, and everyone was surprised. And he said, you know what? The government can't tell people which way to wave the flag. So, well, anyhow. So the answer is yes. There have been many battles. I don't want to talk about many of them. However, I will tell you that Truman, Truman was very upset with the court after the steel seizure case. And Thomas Clark, who we had appointed, Thomas Clark, who was the attorney general, who tells Eisenhower when he's attorney general that, I think if the president ever seized the steel mills, he'd be okay in the time of war. He's appointed to the court and he votes against his old boss. And Truman is so upset with the court that one of the justices, quote, I think he sort of lured him to his home. And then the other justices were there and they had a few words with each other. And then they sort of laughed it off and had a drink. And Truman would tell you what he thinks. Teddy Roosevelt and Oliver Wendell Holmes were very close friends until the trust buster case. They're talking about trusts today. Until the trust buster case came out, and Roosevelt will win, Teddy will win, but Oliver Wendell Holmes will vote against him, and it will shatter their relationship. I'm sorry, I went too long. Are you concerned about the decided on the so-called shadow docket? I think on there, and I've heard that term used, shadow docket is not saying how you rule on something, not giving names, or maybe just giving a per curiam opinion. I think they mean by that. And I was reading about that long and not assigning a name. Well, I could see concerns on both sides of that. And it's probably a discussion for another time, but justices do have to, make their decisions, at one time or another. And I think what you're referring there to, as they're using it, is a per curiam opinion where there isn't a name signed to it, and you don't really know necessarily how they all came down. Okay.
Are
Do
there
I
any
have
other,
another one?
any other questions?
Yeah, it looks
Doug,
like
I
one
haven't
more
heard
just
from
came
Doug.
through.
Oh. Sorry. Yep. At Nebbia's, I know right where that store was. Of course, it was long before my time, but yeah, it was a case that certainly people that had lived over there and locally in Rochester, they had the people knew what was going on. It was a small town quote case. Not many make it to the Supreme Court. In modern era, Supreme Court of the United States gets 10 to 12,000 petitions for certiorari a year. They only take 80 cases. And I'm sure back then they probably took even less. I would guess. I don't know. Do I have any others?
I don't see any others.
Do we,
I can leave it at that. Or you can, would be timely to tell why Tom Clark left the court. I do know why he left the court. I don't know if you know, but if you did and you wanted to tell it, that's fine. I think it had to do with his son being named the Attorney General, wasn't it? And that they didn't want him, he couldn't serve because of they were thinking it would be impropriety or the appearance of impropriety.
Yes, that's exactly right. And his son, Ramsey Clark, just died a couple of days ago, aged
Oh,
93. That's why I mentioned it was timely.
thanks. I didn't know that. Thanks.
Well,
Um,
Lyndon Johnson had wanted to name the first Black to the US Supreme Court, but there was no vacancy. And Johnson wanted to create a vacancy. And he reasoned that if he were to appoint Ramsey Clark as Attorney General, that would create a conflict of interest that his father, Tom Clark, would not wish to proceed with, and that Tom Clark would therefore resign from the Supreme Court. And that's exactly how it worked out. And Thurgood Marshall was appointed, served 24 years until
very good. Very good. On that part, I didn't know. And that's excellent. I always tell people, professors and lawyers have to, be constantly learning. I didn't know that. Can I call you Doug?
Sure.
And I do know another one LBJ did on that along the same lines. He wanted to appoint Abe Fortas to the court, but he didn't have a vacancy. So he asked Arthur Goldberg to become the ambassador to the UN. And Arthur Goldberg didn't know what was up. So Arthur Goldberg, believe it or not, leaves. And as I remember, the story was that he left because he said, when your president calls, duty calls, you go. And he didn't know that this was the subterfuge of all under the guise of putting Abe Fortas on the court. And, different stories about Abe Fortas, who ends up resigning under controversy. And to be honest with you, I've looked at a little bit at that, and I don't, he was getting payments, Abe Fortas, while he was still on the court, and they thought that from his old law firm or from a client or something, and they said that was an impropriety, but from his point of view, he said, I already earned the money. It was beforehand, and I had already earned it. I had the right to it. And to be honest with you, I don't know that he was a controversial guy, but I mean, I don't know that it sounded plausible what he said, that, he earned that money when he's in private practice. So why couldn't he collect the fee? I don't know. But thanks for that story. I'll have to pass that one on.
It's quite a story.
It sure is.
And then,
does anyone else have one
and then when it came out that Clarence Thomas was going to be the Black successor on the Supreme Court to Marshall, Marshall was rather upset about that, but the phrase he used was that his father always told him that you can't tell the difference between a white snake and a black snake. They both bite.
Well, they were certainly judicially polar opposites. Clarence Thomas is very, very talented and a very, very gracious, and he is very interesting. That Kenneth Starr, the former judge, former Whitewater prosecutor, argued, I think, at least 40 cases before the Supreme Court. He wrote that your most original thinker on the court is Clarence Thomas. And Clarence Thomas, well, I will tell you, you'll read one of his dissents or opinions, and you'll say, like, hey, I never thought of that. So yeah, opposites, but each having their place in history. And I have met Mrs. Thurgood Marshall, and very delightful. And is there any other questions, or we'll see? Am I going to? Okay.
I don't see any currently I don't see any more questions. Anybody would like to ask
Normally,
anything?
normally we have to leave the library at a certain time, but because we're not in the library, I guess it doesn't really matter.
Oh, maybe it doesn't matter. Wow.
Are there any other questions?
Any other questions? All right, this is as close as I get to a quote, I'm not a magician. Somebody pick a case, I'll see if I can get the justices. I can't look, I'm obviously not looking. Anyone want to pick one?
Can you holler out or you're,
You gotta know
Yeah.
who's on it though. Maybe go, I always tell my students, go to OYE, OYEZ, and they'll tell you who's on it or anything else like that.
Oh.
See if I can get them.
come on, Doug, you gotta come up with one.
You
Or
want
by
to suggest a
slipping.
case?
What's that?
What was the question? You wanted to suggest a case?
So give me a name of a case where you know all 9 justices, or if there were less than 9 then, and see if I can get them, or how many I can get.
Marbury versus Madison.
Marbury.
It's
Um,
before our
Of course,
time.
there were only 6 at the time, but it's Marshall. Let me see if it should be, Marshall, is it, number 1 is Marshall. Is it, it's not, is Cushing still on the court? I can do some of these. Give me a minute here. I really plan to do this.
Well, it was
All right,
before
well,
my time.
Marshall's 1803, so it's gotta be, the next one would be Iredell. Is he on the court?
It's before my time. I don't really remember, but
If you
You
look
offer-
up Marbury versus Madison,
you offered the challenge. Is Bushrod Washington on?
Bushrod would be on because he was appointed. Bushrod was appointed by Adams, and I think by then he's on there. Bushrod, nephew to George. Let me see. I used to be able to do this. Marshall, see, I told you, see, every once in a while, then I'm just slipping here. Marshall, I thought it was Iredell. Now, the other one was the natural law theorist, and then wait a minute, the one who was impeached but not removed, the only one impeached and not Chase. Chase was on it. Chase, why do I think it was Iredell? Alfred Moore, maybe, who didn't participate.
Yes.
Was Moore on it? Was Chase on it?
Chase, yes.
Was Bushrod on it? He got that one. I think Bushrod Washington's on it.
Yes.
Is Iredell and Marshall?
Marshall, but not Iredell.
It's not Cushing either. Cushing might be gone by then.
Yes. Cushing
He
was
is
on
on
there.
it.
Yeah.
1, 2, 3, 4, 5. That means I need one more. Can you give me the initials?
WP.
William Patterson.
Yes.
Wow, that's extraordinary.
Well,
And we can't leave early now because you got them all, right? It was-
actually, Doug got one of them. Reminded me of Bushrod. So, but
How about Dred Scott?
oh, Dred Scott. All right. Justice Harlan, the first Justice Harlan, writes the dissent. Wait a minute, no, that's Dred Scott. You know what? No, that's Plessy. Dred Scott's before the Civil War, 1850. Wow, 1857. So, in the Dred Scott decision, you've got to have, let me think about. Okay, Dred Scott has to be, if it's 1857, the it has to be Tawny.
I think he was Chief Justice at the
He
time.
was Chief Justice. He actually goes down, Tawny goes down in infamy. What a lot of people don't realize, there are theorists that said that he owned slaves. He freed his own slaves. He believed it was immoral. Tawny will actually write the majority opinion in this self-inflicted wound, infamous case. He thinks he is going to avert a civil war, and instead it precipitates it. Tawny will write that opinion. And so let me go through, let me start to go through.
We're losing
Yes.
people here.
Yeah, you know what? I can't do it. I'd have to think about that, and I don't want to lose people.
Sure.
Very interesting. Thank you so much for.
Well, thanks to everyone here. And
If people turn their cameras on and go to what was there? There was a reaction. You can give a hand clap. You see the little hand clap.
Our videos are turned off by the host.
Oh, I'm sorry. Okay.
All right, I
Well-
can turn 'em.
did I have a former student here? Or did they not?
I believe you did at one point, yes.
Who is Andrea? I wonder. Well, there's only a few of us left,
Hi,
but
I'm Andrea.
who is
Hi,
that?
Andrea. Hi,
Okay.
everybody. No, I wanted to thank everyone for coming. I know that, this is the second one I've done, and it's always fun. We get a good group, and it's always a well-versed group, to say the least. And it's good to have somebody in the audience too who can help me out here and there. And some of you have. I appreciate that. Oftentimes in class, I'll say, now I got 5 sections of this. Can you tell me what's the last thing in your notes? I thought tonight, you know what? I really can't ask anybody here. Could you tell me, bring me back to whatever, to whatever. So it's, just the way that it goes, but it's always a pleasure.
Yeah.
Always, I
Well,
really enjoy it.
Yeah. Join us next month. We have Kathy Britton, who is the curator and manager of the Rochester Medical Museum and Archives. You may
That's
have not
interesting.
even known we had one. So she's going to be, she'll talk about Park Ridge Hospital and how our friend Ralph DiStefano managed to get out hospital in Greece. And
Mhm.
so those of you that live in the neighborhood, stop by Sunday and get some Girl Scout cookies. I see 3 of us on the screen now. Thank you very much, Kathy, who
Yes.
hosts our
You're
Zoom
welcome.
program.
Thanks, Kathy. Thanks, Bill.
And anybody else? And then we can just wave and maybe
Thank you.
maybe clap and
Thank you. Enjoy.
all right. Thank you, everybody. We're losing
Take
people
care.
quickly and
All right. Good night, everybody. Thank you. It was a great presentation.
yes,
All right. Good night.
always learn something. Thanks
Thanks.
again, Jim.
Take care.
All right. Bye-bye.